The Supreme Court today allowed telecom major Vodafone to initiate the second arbitration process under an India-UK investment deal over tax demand for more than $2 billion, or about Rs 11,000 crore. The tax demand has been raised out of Vodafone's entry deal in India 10 years ago. World's second largest mobile operator Vodafone entered India in 2007 after it acquired Hutchison Whampoa's wireless assets. The Vodafone has contested tax demand of over $2 billion arising out of its acquisition of Hutchison Whampoa's assets.Â. Vodafone has already initiated one arbitration under India's investment agreement with the Netherlands. A Supreme Court bench of Justices A.K. Sikri and Ashok Bhushan heard the case after the counsel for the telecom company called for early hearing yesterday. An additional Solicitor General Mani Nder Singh did not raise any objection. A Justice R.F. Nariman had recused from hearing the matter on December 8. Vodafone tax demand case, things to know. The Supreme Court's order came on a plea of the centre challenging the Delhi High Court ruling asking it and the Vodafone Group to participate in dual arbitration proceedings initiated in connection with a tax demand of Rs 11,000 crore through a retrospective law. The government is of the view that the $11 billion acquisition of stake of Hutchison Telecommunications International Limited, HTIL, in Hutchison S.A. Limited, HEL, by Vodafone was liable for tax deduction at source, TDS, under the Income Tax Act. As Vodafone had not deducted the tax at source, the government had raised the demand of Rs 11,000 crore, which was subsequently quashed by the Supreme Court on January 20, 2012. Thereafter, the government made a retrospective amendment to the Income Tax Act which refastened the liability on Vodafone aggrieved by the imposition of tax. By the retrospective amendment, Vodafone International Holdings BV, VIHBV, a Vodafone Group subsidiary, had invoked the arbitration clause under BIPA between India and Netherlands through a notice of dispute of April 17, 2012 and notice of arbitration of April 17, 2014 while the proceedings under the India-Netherlands BIPA were pending. Vodafone had initiated arbitration under the India-UK BIPA as well on January 24 this year. Challenging the second arbitration, the government had said the two claims were based on the same cause of action and seek identical reliefs but from two different tribunals constituted under two different investment treaties against the same host state. The High Court had asked Vodafone representatives to participate in the process of appointing a presiding arbitrator in its international arbitration process against India. On October 26, the High Court had allowed the telecom company to participate in the second arbitration against India on the same issue of tax demand. The High Court had on August 22 restrained Vodafone from participating in the arbitration initiated under the India-United Kingdom Bilateral Investment Protection Agreement, BIPA, in connection with the tax demand raised against the company in relation to its $11 billion deal acquiring the stake of Hutchison Telecom. Earlier, the company had initiated a similar arbitration process under the India-Netherlands BIPA on the same issue and the proceeding on it is going on. The High Court on October 26 had given the centre time till November 17 to indicate whether it was amenable to rescheduling of these proceedings after a final decision is given in the first arbitration. The court had said it was not in favour of stalling the process as both sides had already appointed an arbitrator each in the second arbitration. The telecom major had told the High Court that the company was not looking for a declaration or award from the two arbitration and anyone would do. Vodafone had claimed that the centre had not disclosed to the court an undertaking it had given to the International Court of Justice, ICJ, to appoint an arbitrator. The centre had, however, opposed the contention denying that any such undertaking was given and said it was rather forced to appoint an arbitrator. The Union government had opposed the arbitration proceedings under the two BIPAs, claiming it was an abuse of the process of law. The government had earlier contended that disputes encompassing tax demands raised by a host state were beyond the scope of arbitration provided under the Bilateral Investment Treaty, as taxation is a sovereign function and can only be agitated before a constitutional court of the host state. The centre had also argued that laws passed by Parliament could not be adjudicated by an arbitral tribunal and did not fall within the ambit of BIPA or any other international treaty.